Hello, everyone. Let me get situated here and bring the parties in and get started. As I mentioned, I've put this emergency hearing in here on a complicated landlord-tenant matter.
Judge Middleton has called an emergency hearing in the continuing saga of Whose House Is It? From the onset, this has been the most interesting case we have ever seen. As happens so often, the complicated legal matters and the weight of everything on the line in this case has led to bitterness between the parties. If you have not yet seen parts 1 and 2, there will be a link in the description. They are well worth your time. Let's see what emergency brings us here today.
Good afternoon.
Good afternoon.
Good afternoon, Your Honor.
Good afternoon. I set this on pretty short notice. I appreciate everybody accommodating that. We had a jury trial set for this, two of them set for this morning. One defendant didn't show up and the other one entered a plea. So I had a block of time open for this, and this was time sensitive. So I've scheduled it for today. So let me call it. It's Rosemary Blair versus Joseph O'Donnell and Carla Bowers, plaintiff and defendant, and they now became counter plaintiff and counter defendant. Also, third-party defendants Mark Verpalat, Patrick Blair, and Karen Stiver. Matthew Hauser is here for the plaintiffs. Daniel Hatch is here for the defendants. And Mark Verpalat, I'm not sure if he's pro per or what his circumstance is, but they're not here yet. We have 5 minutes till the actual scheduled time. It's a request for a protective order under the court rule having to do with some discovery subpoenas and depositions that are requesting to be taken. Mr. Hauser is objecting to having those discovery subpoenas done at Mr. Hatch's office in Grand Rapids. Do you wish to speak to that any further, Mr. Hauser?
I guess just by way of,
well.
Oh, I'm sorry, just by way of some quick clarification, there was an update submitted to the court on Monday just to indicate that Attorney Hatch and I, when we were both down in person on April 27th, did discuss having the depositions at my office. I believe now all 3 depositions have been re-noticed to my office, that being the deposition of Miss Rosemary Blair, Miss Karen Stiver, and Mr. Patrick Blair. As of May 4th or so, the depositions of Miss Stiver and Mr. Blair have been adjourned for a future date, but the deposition for Miss Rosemary Blair is still on. And the long and short of it, the request is just to have the depositions be held at the St. Joseph County Courthouse, as that's going to save my client a little bit over of an hour and a half of drive time. And given the fact she is 82 years old and already driving from Crown Point in Indiana, if we're able to save her that time, especially since she has some hesitations taking I-94 and the like, I feel it's a very reasonable request to have her deposition be held at the courthouse. Thank you, Your Honor.
All right, so if there was an update, it hasn't made it to me yet. So some of the depositions will be done at your office in Battle Creek.
If I may respond, Mr. Hauser's motion is incorrect and his representations here are incorrect. I noticed originally Rosemary Blair's deposition at Mr. Hauser's office. He put in his motion that it was noticed at my office. That's not true.
All right, that's what I understood.
I originally noticed Miss Stiver and Mr. Patrick Blair's deposition at my office when they were in pro per, because they weren't represented by counsel. After many back and forth with Mr. Hauser trying to figure out if he would represent them, he has filed an appearance on their behalf, and I'm totally okay with taking their deposition now at Mr. Hauser's office. So I typically don't notice depositions at my office for opposing parties unless they're in pro per, because I don't know where they live. I don't want to take the deposition at their house. The court reporters aren't comfortable. I don't know if they have tables. So that's the only reason that their depositions were at my office when they were in pro per. But Miss Blair's deposition has always been noticed at Mr. Hauser's office. And to be honest with you, Your Honor, I've never had an opposing counsel object to producing their clients at their office for a deposition. If you look at Mr. Hauser's motion, it looks like Miss Blair would save 15 minutes traveling 2 hours to the courthouse or 2 hours and 15 minutes to Mr. Hauser's office. She chose to be represented by a lawyer in Battle Creek. The burden is actually more on my clients to have to pay. I mean, it logistically makes no sense to have Mr. Hauser travel another hour to the courthouse, have me travel another hour to the courthouse, have both of our clients incur more fees and costs to convenience Miss Blair for traveling 15 less minutes. So the standard is good cause under 2.302. There is no good cause, and it's to prevent annoyance, undue burden, embarrassment, undue expense, or oppression. And if the court were to order the deposition at the courthouse, it would actually go against that as an undue expense on both of our clients. So we haven't had a chance to respond because Mr. Hauser in writing filed an amended motion, and we had to get it in today. But I hope the court would take that as my response. The standard hasn't been met, and I quite frankly think it's incredibly inappropriate to not have a client's deposition at Mr. Hauser's office.
If I may, in brief response to that, Your Honor.
Yes.
Attorney Hatch indicated the additional drive time from the St. Joseph County Courthouse to downtown Battle Creek is an additional 15 minutes from Miss Blair. I have no idea how one could make that drive in 15 minutes. If Mr. Hatch is aware of a way, I would love to know. It would save me considerable time every time I need to appear in St. Joseph County. It's about 45 to 50 minutes between those 2 points. The additional drive time for Mr. Hatch, as I did a cursory review on Google Maps, is about 10 minutes each way. Myself, I'm adding about an hour and a half round trip. But Ms. Blair, who was already driving over 2 hours just to get to the state line, is saving about an additional hour and a half. Given the fact she's 82 years old, and this is going to be a rather lengthy day, I'm sure. If we can save her an hour and 15 minutes, I'm certainly willing to come to St. Joseph County to save her a little bit of drive time.
Judge,
Yeah.
if I may, I didn't say that it was 15 minutes from Mr. Hauser's office to the courthouse. What I said was in paragraph 4 in his motion, he says from Rosemary Blair, she lives somewhere in Indiana, Crown Point. Never had the pleasure of being there, but it's 2 hours and 15 minutes from Crown Point, where Miss Blair lives, to Battle Creek. It's 2 hours from Miss Blair's home to the courthouse. That's 15 minutes. So I'm not saying that it's 15 minutes from Mr. Hauser to the courthouse. We're arguing over 15 minutes here for a deposition.
Yeah, I was hopeful that you guys could work out a settlement of this very complicated case. We can't even agree on where the deposition is going to be and whether it's 15 minutes or 45 minutes. There's a lot of acrimony in this case that mitigates against resolving it. And this is expensive. The clients are being billed to argue about this. It's a matter of geography. I suppose it depends on which way she comes. If she comes from Chicago via the Indiana Toll Road and up through Sturgis on M66 it's probably an additional 45 to 50 minutes, as Mr. Hauser says. If she comes straight up the Indiana Toll Road, I-94, and came I-94 south on 131 to Three Rivers to Centerville, it's probably marginally shorter than to continue on I-94 to the courthouse in Battle Creek. If you do it that way, it is 15 minutes or so difference. If you do it the other way, the other thing is she's paying her attorney to travel from his office to the courthouse here in Centerville. All right, I just received this. I'm really enjoying all these additional complicated pleadings in this case. I think I got a handle on things, and then I get a 29 pages more stuff. So it happened when I got back from vacation, and more of this. We do have hearings in May. Anyway, I'm disappointed. And I understood from the pleadings, and I didn't get this amended motion till just now, that I thought the deposition was at Mr. Hatch's office in Grand Rapids. And I thought, well, that doesn't seem unreasonable to have the deposition here at the courthouse. So it's a difference of which way she comes. She comes up I-94. It's really not that much. Might actually take her less time to get to the courthouse in Battle Creek than it would to get to the courthouse in Centerville. She'd have to go south on 131 through Schoolcraft, through Three Rivers, where three bridges are out. You can't get from here to there. I feel bad because I don't know how much money just got spent fighting about this, but I'm going to allow the deposition to be at Mr. Hauser's office. It will actually save her money that she won't have to pay him to drive back and forth to Centerville. And if she comes up I-94, it may actually take her less time to get to Battle Creek than it would to get to Centerville. I am still hopeful that some settlement can be reached, not because I'm lazy and I don't want to do it. In point of fact, some of this may end up being removed to circuit court. I think it's just in everybody's interest to come to some resolution of this. But that's not up to me. I'm here just to do my job. So, Mr. Hauser, I think this motion was made in good faith. Your client contacted you, but as a practical matter, it's not going to take her any longer to get to your office than it is to get here if she comes up I-94. It would be 45 minutes less if she came up the toll road, but so I will do that order. Hopefully these depositions may get you somewhere closer to where you need to be. I've got a new batch of pleadings to digest. When we're here later in May, we still have a lot of heavy lifting to do here. But as far as this is concerned, the deposition will occur May 16, 2023 at 10 a.m. at Mr. Hauser's office on Michigan Avenue in Battle Creek. All right, anything further we need to do here?
Just briefly, Your Honor, you mentioned the May 26th hearing, and I would like some clarification on that. My understanding from attending the last hearing on April 27th and reviewing the live stream is that a default was entered against Miss Blair with respect to her counterclaim. And the hearing on the 26th is an evidentiary hearing on my client's damages with respect to the claims asserted against Miss Blair. I got a witness list, an exhibit list from Mr. Hauser that names 15 witnesses, including 2 doctors, for the May 26th hearing. Some are neighbors, some people I don't even know who they are. They don't identify what companies they're with. None of those witnesses have anything to do with damages. So I don't know if Mr. Hauser intends on trying to relitigate the motion for defaults, or to try to have a termination of tenancy hearing, but my understanding at the last hearing was that a default was entered in favor of Joe O'Donnell and Carla Bowers with respect to all of our counterclaims against Rosemary Blair. We've submitted the order to the court. They're entitled to exclusive and immediate possession of the property. So rather than filing a motion in limine and to have the most efficient process start at 2 o'clock on the 26th, I guess I would just ask that, I mean, am I misunderstood that the hearing on the 26th is about our damages?
No, you're not. I thought he was gonna move to set the default aside. I'm not sure, I can't remember if that had been pled or not. So, and
I think-
well, the time on the 26th is going to be inadequate for what we have to do. But no, we aren't gonna relitigate the termination of tenancy matter. I also have a proposed default against Mark Verpalat for failure to respond to the counter plaintiff's request. I haven't yet seen anything, so I think I'll go ahead and enter that. File 221862, it's a request for a default on the counter defendant Mark Verpalat for failure to answer. Yes, I found in your favor. I found, well, first of all, there were two. I found that it violated the lockout statute, but then I upheld your default, which was all your claims.
Right.
Then there's questions about what I have jurisdiction of. Do I maintain jurisdiction of the equitable claims? Do I maintain jurisdiction of damages over $25,000? Because this is district court, not circuit court. I, point of fact, probably could block out 5 days to litigate all the issues in this case, and I don't think we'd be done yet. But yes, a default entered, it has not been set aside. And you stated on the record more than once that you were prepared to argue the issue of damages on the 26th. And they could be substantial. They could be treble damages. There's issues, as I mentioned, about the change in the interest rate. And the costs that Mr. O'Donnell incurred as a result of this lockout. So yes, I suppose we're going to have a lot of arguing to do, but no, my intention was not to relitigate your termination of tenancy claims or her termination of tenancy claims. I filed on behalf of the defendant.
That
Maybe you guys, yes.
Oh, I'm sorry. I
Go
guess
ahead, Mr. Howard.
just make sure we have all the documents up to date. There was a motion and affidavit to set aside the default that was filed on or about April 28th. It was my indication that the court did have a copy of that. Is there one in the file? Because that was set for hearing.
Yes, I believe I do. And I think I set that for hearing at the same time. But I don't need, we have to get past that hurdle before we get to litigating the claim again. So I would not summon all those witnesses to court that day. Yes, I believe it was filed. The pleadings in this case are this thick. And I think I got a handle on it, and then I get more pleadings, which I got today. So yes, I guess we'll be hearing the motion to set aside the default. And then depending on where that goes, the issue regarding defendants' damages. Also, I have signed the default judgment against Mark Verpalat for failure to answer his counter complaint, the third party defendant. So you guys will all be in the same place at the same time on Tuesday at Mr. Hauser's office. Any progress that's made is fine. If it isn't, we will use the 3 hours we have set aside, try to inch this matter closer to the finish line. Summer is coming. People want to use the property for its intended purpose as a dwelling. There are issues about personal property that's missing. There are issues about the expiration of the land contract. There are a lot of unresolved issues here. And if we have to fight it every step, I guess we'll do that. It's just going to be awfully expensive for each side. All right, so I will do an order indicating the deposition shall be on May 16th at Mr. Hauser's office at 10 a.m. And I've signed the default on Mark Verpalat. Next thing we'll be getting is a motion to set that aside from him. And we'll deal with Miss Bowers, excuse me, with Miss Blair's motion to set aside the default, and then the issue regarding damages. All right, I will see you on the 26th of May. I'll do that order as soon as I sign off. Thank you.
Thank you. Just brief, sorry, very, very briefly, Your Honor. So the 26th will be prepared to argue the motion to set aside the default, and we'll have our response. And at that hearing too, just to make sure I don't waste the court's time, I'll have my witnesses and exhibits ready for a damages hearing if assuming that is not set aside. So that's my understanding of the time on the 26th. And then I just want to make sure, because I do have a deposition scheduled for Miss Blair's doctor that claims she lacked capacity to sign the land contract on the 18th of next week. I don't see it now that we have clarity on the hearing for the 26th and the exhibit list. I don't see a need to conduct that deposition because a default.
Well, there are issues regarding that, as you argued at our last hearing. On one hand, she said she didn't have the cognizance to enter into such a contract, but she used it as a sword to terminate the agreement. But when it was used by the defendant to sustain their right to possession of the property, she claimed that she wasn't competent to enter into it. I'll leave that up to you, whether you think you need to depose that doctor or not. It could perhaps be delayed. If the motion to set aside the default is denied, it won't become relevant. If it is, it may still be. But again, all of this is expensive. And I'll just leave it at that. So I'll leave that up to you. The other depositions, I think, may help get you to where you need to be.
Right. The only reason I would take that deposition if she was going to be called as a witness on the 26th, from my understanding, she's not going to be, even with the motion for default is not set aside, and we do go with damages, that the doctor has no relevant testimony with respect to damages. So that helps, Your Honor, because I'll adjourn it out. I hate to keep incurring costs.
Well, there are still some issues. I'm unclear as to the $85,000 that was allegedly tendered, and then it was some sort of promissory note. I don't have a handle on whether Miss Blair actually got $120,000 of O'Donnell's money or something less than that. All right, I'll leave that up to your discretion. If you don't think that we need it for damages, then we won't deal with it. If it becomes relevant later, I guess it could always be renoticed.
Certainly.
All
All right.
right.
Thank you, Your Honor.
Thank you very much, Your Honor.